Hi, Patrick. Am I audible?
Yes, hello. Hi.
Hi. Nice to meet you. I'm Oindrila from Human Rights Law Network, Delhi. We'll be waiting for another, say, 5 to 7 minutes, and so that more people can join in, and then we can start.
Okay, great. Sounds good.
Yeah. Okay. Hi, good evening, everybody. I think we'll start now. We have around 30 participants here, and I think more will be joining in. So I would go ahead with it. Today we have with us for our CCRI lecture, Mr. Patrick Kroker. He will be speaking on the universal jurisdiction and litigation in Germany on crimes against humanity committed in Syria. A little bit of introduction about Mr. Kroker. He has studied law at the University of Leipzig, Trier, and Lisbon. He worked as an assistant to civil party lawyers at the extraordinary chambers in the courts of Cambodia. And in 2012, he completed his PhD on the subject of victims' participation in international criminal proceedings at the University of Hamburg. He also has worked as a research assistant at the University of Hamburg and the Hertie School of Governance in Berlin. In 2014, he was awarded a postdoc fellowship at Harvard Humanitarian Initiative and the Goldsmiths College, London. He is a registered lawyer with the Berlin Bar and has worked with the European Center for Constitutional and Human Rights since 2015, where he has been responsible for ECCHR's work on Syria. In his capacity as a lawyer, he acts as a civil party representative in the Al-Khatib Trial in Koblenz. Mr. Kroker will be speaking about the universal jurisdiction cases currently happening in Germany, with a focus on cases concerning crimes against humanity committed in Syria, especially the Al-Khatib case, before the higher regional court in Koblenz. I'm so sorry if I've butchered any pronunciations. I tried to Google as much as possible, but I'm extremely sorry for the pronunciation. I think I'll ask Mr. Kroker to take over. I would ask everyone else to kindly mute themselves. I would ask whoever's not speaking to themselves. Yes, I think we can begin.
Great, yeah. Hi, everyone. Good evening to you, and thank you very much. First of all, for the nice introduction, and to HRLN and CCR to offer this opportunity to speak about our work, and for all of your interest. It's really a pleasure to be speaking to you, and I'm looking forward also to discussing a little bit about the topic later on. So universal jurisdiction cases in Germany, especially with regards to Syria, is the topic, and I will basically first frame that a little bit. I will speak a little bit about the context of the crimes committed in Syria, because I'm not sure how aware everybody is of that, and then I will set the frame of international criminal law, and especially international criminal law in Germany. And then in the second part, I will say how that basically translates into a prosecutorial strategy here in Germany, and how we with the ECCHR made use of that in litigation. I think I still hear somebody else. I don't know if there is a question, or if it's just that somebody wasn't muted.
Yes, I've muted them. There was somebody who was unmuted. I've done that.
Okay.
Yeah.
All right. Good. Yeah, but speaking of somebody speaking later on, I hope that we will have a fruitful discussion in the end. So I'll leave plenty of time for that. I think I should speak about 30 to 40 minutes, and I think that there will be enough time then, hopefully, for questions and discussions. So speaking about the context that we are working on here, that is Syria. You all probably are well aware that in February 2011, March 2011, the so-called Arab Spring kind of moved over to Syria as well, which many believed at the time would not be possible, because the dictatorial grip on civil society was so tough, even in comparison to other countries such as Tunisia and Egypt. But in 2011, it actually happened. And the Syrian regime, the Syrian government under Bashar al-Assad, the way they reacted to it was that they basically intensified the very brutal grip that they had on any opposition and on any civil society, really, with a long established system of secret torture prisons, mainly run by the Syrian Secret Service agencies. I have to say, there are quite many, and they are very powerful in Syria, and they have for a long time basically orchestrated a torture system, but this torture system was then just enlarged and intensified in order to counter the demonstrations that were taking place starting in 2011. And this resulted in torture and enforced disappearance and unlawful detention on a huge scale. We are speaking of hundreds of thousands of people, almost in every family where people are not per se completely in line with the Syrian government. People know relatives that have been detained and tortured. It's a very, very common experience in Syria. And in some families, many members have actually even died under torture or have been in torture prisons for a very long time. So it's been pretty clear, and it has been from a very early point onwards, basically since I think May or June 2011, that this would likely amount to crimes against humanity as an international crime. It was UN commissions of inquiry that were already from the very beginning documenting this, but also numerous human rights organizations, etc. And the label crimes against humanity has been put on that from a very early point in time. Of course, it didn't really change anything, but that's one of the I would say characteristics of the uprising in Syria and the crimes as well, is that they are extremely well documented, also in comparison to other conflicts, because you had quite a system of international agencies and human rights organizations active, but you also had a lot of activists. I mean, this is basically the first huge conflict where in the era of the smartphone, so also a lot of that documentation has taken place. Next to this torture and disappearance system, very important crimes to mention is sexualized violence in many forms, but very often happening in the secret detention, and very often also obviously targeting women who for many reasons are in a much more precarious and dangerous situation when they are being detained, and they are subject to a very high risk of suffering from sexualized violence. So it's not exclusively women, also many men, but of course there is a very important gender discrimination aspect that plays into this as well, particularly because women that are only believed to maybe have been their sexual dignity, so to say, violated in these prisons, also suffer later on from consequences from a very traditional and patriarchic society in Syria. And then also another crime that has been quite discussed internationally quite a lot is the use of chemical weapons. That is also one of the international crimes that the Syrian government has allegedly committed. So this is the kind of context of the facts that we speak about. Now, when it comes to international criminal law, I mean, this is precisely the kind of situation where, in 2002, the International Criminal Court was founded for, with the Rome Statute that codifies exactly these, ideas that basically have developed since the Nuremberg trials against the Nazi war criminals that quite recently actually had their 75th anniversary, and where a lot of the ideas and the spirit behind it was founded. And despite the fact that since 2002, there is a world court for these kind of crimes, this court could not get active in the Syrian situation. And this is due to the fact that Syria is not a state party to the Rome Statute, so to the international treaty that is basically the founding document of the International Criminal Court. And so the only way that the court could get active in this situation would be through a Security Council, UN Security Council referral, but Security Council decisions are subject to vetoes, and such a referral has been vetoed by Russia and China. So we see again, as many times in international criminal law, the big powers basically in this world, and this goes way beyond Russia and China. It includes the United States and also India. Whenever it gets uncomfortable, they rather prefer not to have an international body investigating, which is why many international big powers, or basically all of them, are reluctant to become state parties even, and also to refer cases to the International Criminal Court that for them might be uncomfortable, or for their allies and Syria being an ally, the Syrian government, to the Russian government, at least very much so since 2011. So we have one of the largest crimes and most horrible crimes and the largest extent of crimes of the century on the one hand, and on the other hand, we have no way of getting close to any accountability. There is a huge accountability gap and very, very widespread impunity. And this is basically where we, or many also, and prosecutors, etc., use the idea of universal jurisdiction. So in international criminal law, I mean, the codified law, basically, when it comes to its enforcement, there are three different pillars how international criminal law can be enforced. Obviously, one is that the state that has the original jurisdiction exercises it over these crimes, which in many, many cases, of course, is not going to happen because it's in many cases the state that is committing the crime, so they will not prosecute them. So in this case, this would be Syria that has the original jurisdiction over these crimes, but obviously they're not going to indict their own president and the most powerful people in the country. But this is kind of an idea that in theory could work. On the other hand, there is the International Criminal Court, but then as a third pillar, and I would argue kind of equally among the other two, is the concept of universal jurisdiction. Basically allowing any country in the world to assume jurisdiction if we have specific crimes that have been committed, the so-called international core crimes, that is especially genocide, crimes against humanity, and war crimes. Now, universal jurisdiction is a principle of international law. It is, for example, very precisely enshrined in the Genocide Convention. However, how a state then exercises universal jurisdiction, and if they allow it at all, is very much, the affair of that very state. So it depends a lot on how the states actually exercise universal jurisdiction. And here we turn to Germany now, because Germany has a very wide application of universal jurisdiction and a very active practice right now, probably the most active practice in the whole world. And at this point in time, I would like to start to show you a little presentation, or just basically some of the law that you can have a look at it in the English translation. So I'm trying to find the screen share button. Okay, it says that the host has disabled this screen sharing. So maybe if you could enable that, that would be great.
Just 1 second, I'm on it. I'll just enable.
Sure, no problem, no problem. I just continue, and then you can just give me a sign and jump in whenever it's possible, and then we can do the screen sharing. So the German legislator has, when the International Criminal Court was basically starting to work in 2002, has decided to pass their own law codifying international crimes, such as genocide, crimes against humanity, and war crimes. Many countries have done so. Germany has done so at a very early stage. And so since 2002 also in Germany, what entered into force is the Code of Crimes Against International Law. And this is basically that in the first place, as I said, codifies all these crimes, what is genocide, but then under German law. I mean, they basically took it from the international level and modified it slightly so that we have a German provision now on genocide, on crimes against humanity, on war crimes, and recently also on the crime of aggression.
Sorry to cut you off, Patrick.
Yes.
I've enabled the share screen option. I think you can try now.
Ah, yes, great.
Yeah.
Okay. Do you see the slide?
Yes, I can see it.
Okay, perfect. So this is the Code of Crimes Against International Law that I was speaking about, entered into force in 2002. And then, as I said, in section 1, it defines the scope of application. And here we have basically, it's an excerpt, but I wanted to make it a little bit, less text so that you get the gist of it. The main part, how basically what a universal jurisdiction provision looks like. And you see that And this is something that is different than in many other countries in this world, that in principle, there is no limitation whatsoever. It just says this code can apply to anywhere in this world. And this is quite rare. Many times you have provisions that limit already this principle from the very beginning. We see in a minute that it's also limited in Germany, but at a later stage, namely at the stage of investigation when the prosecutor is becoming active. But the principle, I mean, this is quite a strong statement that the law itself states universal jurisdiction as a principle with no limitation. Then, however, at the same time, in the German Code of Criminal Procedure, there was a clause that was inserted that makes this much more complicated, so to say, and also puts a lot of power with the prosecutors. It's a very lengthy provision. I have some excerpts of it that becomes basically the most important parts. I will give you a couple of seconds to just get an overview of what it says before I continue. So as you can see here, and I try to highlight, the most relevant parts so that you find it faster, that the way that the principle of universal jurisdiction in many cases is limited in other countries. In Germany, it's a bit vice versa. The principle is unlimited, but the prosecutor has a very wide discretion to limit these cases themselves if there is no connection to Germany. So in many other countries, for example, France, they have a very clear clause that only if a French national is somehow involved in these crimes, no matter where they were committed, then does French universal jurisdiction apply. In Germany, it's worldwide, but the prosecutor has a lot of discretion in not taking on cases that have no relation to Germany. And this is also important to know that the discretion basically of the prosecutor is not only very wide, but it's also in almost no way subject to judicial review, which, from our perspective, coming from the perspective of human rights litigators, is very difficult, because if they decide not to take a case, then there's hardly anything that you can against it, as long as they base it on this provision. So now turning to how this translated into the prosecutor's strategy when it comes to committing to the crimes committed in Syria. So I said that in March 2011, the uprising in Syria started, and also the really massive crimes started. Those of you maybe remember international news from back then, that the demonstrations, for example, as early as April 2011, were shot at with live ammunition, killing dozens in one demonstration and maybe hundreds in the next week, etc. And this was the point in time also when these incidents were labeled as crimes against humanity by international mechanisms like the Office of the High Commissioner for Human Rights of the United Nations, that Germany started a structural investigation into the crimes in Syria. Now, a structural investigation is a full-fledged investigation under German criminal law, but it has a big difference to other investigations. There is no suspect yet. Normally, investigations are always tied to a specific suspect. When you have a structural investigation, you investigate, as the name says, the structure and the context of a specific crime. And this is something that in its importance really cannot be underestimated when it comes to a successful prosecution of international crimes, because these are, in almost all cases, mass crimes, or also referred to as macro criminality. So they have an element of collectivity in it, and it is even visible in the crimes themselves. In genocide, you need to have the intent to destroy a whole population. In war crimes, there is a widespread and systematic attack on a civilian population. In crimes against humanity. And in war crimes, you have the link to an international or non-international armed conflict. So you always have a context element that is tied to a really complicated context, basically, that becomes relevant even if you want to make the assertion, has there been an international crime committed or not? So you need to have an understanding, a very deep and thorough understanding of the context if you want to investigate that. And this you cannot have when you learn basically that a suspect is coming to your country and you start investigating then. Well, basically you need years, right, to understand command structures, who is who in this crime scene, etc. Because in many instances, when we speak about international crimes, we speak about crimes being committed by states, and so you must really know that whole context. In order to do so, the federal prosecutor started doing a first structural investigation. One of the aspects that motivated them to do so was an increasing number of refugees arriving in Germany. And basically since 2011, people have arrived here, and the prosecutors wanted to be able to detect and prosecute criminals that would potentially be arriving as well one day. And this is what has been labeled by an Argentinian scholar named Maximo Langer, who lectures in California, as the no safe haven approach. Countries don't want to be a safe haven, a potential safe haven for these criminals. That's why they want to basically already have some evidence at hand. Then there was another motivation behind that, and that was to secure evidence for any future use. For example, if ever a suspect would be coming, but also if another country or another body would maybe one day investigate these crimes. We mustn't forget that until 2015, there was still a huge hope that the International Criminal Court would get the mandate to investigate these crimes. So the German prosecutor said, let's secure the evidence for now. Maybe we'll hand it over one day to the ICC, to the International Criminal Court. And this has been labeled the complementary preparedness approach in these kind of investigations into international crimes. And there's one more that I will speak to in a minute. First of all, maybe now coming to our role and the litigation that we have done in these crimes. So basically, since the first structural investigation into Syria started, we supported it with, I would say, limited resources, mainly by facilitating that witnesses that would come and be referred to us, that would arrive in Germany and would ask, people, look, I have lived through these and these things in Syria. Can I speak to anybody in Germany? Then, with the work that we are doing, it would be quite likely that somebody would refer them to us, because we are specialized in precisely that. And in the beginning, we were thinking, well, the German federal prosecutor, they're investigating. It's only a structural investigation, but let's make it possible for these people that they can come and testify. And this has been going on for quite a number of years. But then throughout the years, when we didn't really see any visible results, we reassessed our strategy a little bit. That was in 2016, roughly. And this was mainly due to the fact that a lot more people had arrived to Germany, a lot more people from Syria, especially. You probably also remember in 2015, there was the big wave of people coming here especially to Germany, but to all over Europe. And Germany opening its borders, etc. And generally more and more people had come to Europe also because of the relative geographical proximity. And that also meant that a lot more activists basically had come to Germany as well, and people from the Syrian civil society that really played a great role also in the opposition and also in the movement for democratization in Syria. And so together with them, we sat down and we considered what had happened so far, and we were really not satisfied with the fact that until that point, there really wasn't any strategic investigation taking place. I mean, a structural investigation, can be understood a little bit like a big basket where you just put in everything, that concerns crimes committed in Syria. But we thought that now, especially, as I said, in 2015, afterwards, it was clear that there would be no Security Council referral anymore. So it was clear universal jurisdiction would be the only way of accountability for these crimes committed. And Germany is in a really good position to do more. that's basically how we revised our strategy, and targeted specific individuals that were still active in Syria and that were active on a very high level with criminal complaints that we filed. The reason why we did so was also because we have a strong belief that it is necessary to address the high-level perpetrators in such a situation because of the fact that these are structural crimes. I mean, these are crimes that have been committed from within a certain structure. And if you just have a number of cases of low-level perpetrators, the structures are still going to exist, and the likelihood that the same crimes will again be committed from these structures is very high. So that's why we thought we really need to address this high level. And another factor that was really important when considering what we would do afterwards was that not only did many activists arrive, but I mean, the amount of evidence at that point was really striking. There was so much evidence, first of all, from all the people that arrived, because of course, contrary to what many right-wing politicians might try to tell the German electorate, hardly any criminals came here, but to the vast majority, these are people that have suffered a lot and that can therefore also give eyewitness account to the atrocities that they lived through. That's the very reason why they came here. So there were thousands of witnesses here. There was a lot of other evidence that the prosecutor had collected since 2011. And that's why we thought, okay, this needs more, basically. And so what we started in 2017 was that we launched criminal complaints, 8 so far, in 4 European jurisdictions, all of which have universal jurisdiction possibilities to some degree. And we targeted 26 high-level perpetrators that are basically running the security service system. If you remember, the security service system is basically the one running the torture system in Syria. They are the ones that are running the secret torture prisons that exist already for a long time. We have not named President Assad in the criminal complaints himself, because he is, according to the mainstream opinion at least, shielded from prosecution by a third state as long as he is in office. Not, however, at least I would argue, by an international body, but as long as we are on the level of a third nation trying to assume jurisdiction, he would be shielded. But nevertheless, of course, all the evidence that we are collecting and that our partners are collecting can be used against him some point in time, hopefully. So we did this together with Syrian partner organizations that, as I said, have arrived more and more in Germany and that are really very important to us. And also we have done this together with, by now, and overall more than 100 survivors of torture or family members of people that died under torture. And that we are closely working together with, and they are actually, and this makes the big difference to many of our other cases, they are here in Europe, so they are either in Germany or in one of the other countries where we filed criminal complaints, which is Sweden, Norway, or Austria. And this has really created a big wave, I would say, of attention, but also of activity with the Federal Prosecutor's Office. I mean, especially because, you know, the topic of refugees and the people being here, etc., has been something that was quite present. But I think also the prosecutors were quite happy, even, although it was a very challenging move that we did, that somebody is publicly saying that they should do more with that. It I think also contributed to some part to them daring to take a next step. So this is basically the point when we started our legal intervention with partners. And this then in 2019 led to the issuing of at least one, but likely more, international arrest warrants in Germany against one of the top level secret service guys in Syria, the former head of the Air Force intelligence. His name is Jamil Hassan. in 2019, which was really, I would say, a big thing, so to say, in international justice and in international criminal law, because it's for the first time that Germany has made such a move, and it was for the first time that it was done by a state against somebody who was still in office, actually. And since I have mentioned, from more the academic work, what kind of investigation and prosecution approach that is, going back to Maximo Langer and his work on universal jurisdiction. And I'm happy to share also some reading material to those who would be interested afterwards. Just drop me a line or to HRLN, and I can send you, for example, this article. He would label that the global enforcer approach. So basically he, at the time, when it comes to universal jurisdiction practice by prosecution authorities, has said, on the one hand, there are countries that have a no safe haven approach. They don't want to go outside of their own territory. They just want to keep their own country safe, basically, and want to be prepared for that. On the other hand, there are countries that actively reach out and try to do these prosecutions. And the arrest warrant against Johnny Hassan is such a move, and kind of in between is something that was labeled by another academic as the complementary preparedness approach, where it's securing evidence for whichever future use. I want to say also something going beyond the law, basically, because this is important. When I speak about legal intervention, it goes beyond litigation. That's why the word is a different one. In our understanding and in our vision, these mainly legal moves and these legal tools that we have used, they have to be complemented, because otherwise we risk, especially as being the German white lawyers in this, to do something that is detached from the situation on the ground, so to say, and from making a real difference in the civil society overall. And so our aim is always to come to a dealing with the past and to some form of accountability in the wider sense. And I think, or it is my belief at least, of course it's a hypothesis, that steps, of criminal prosecutions, they are maybe even a condition of a wider societal movement, but they can always certainly only be part. But I think they sometimes enable, or at least enrich, other forms of, people sometimes call it transitional justice. It's a difficult term to use in this context because there is no transition. I mean, Assad is still in power more firmly than ever since 2017, but of civil society that is to a very large degree by now driven outside of Syria. I mean, really all the critical voices, several million people are residing outside of Syria, and for there to be a movement that kind of translate the energy that there was trying to overthrow this dictatorial and corrupt government, at least now trying to come to terms with what happened and demanding accountability for these really horrible crimes. And this can only be done with many other disciplines as well, not only the law. It has to also come with history and storytelling and the arts and exhibitions, etc. And it can only be done, obviously, if it is carried, so to say, and owned by Syrian civil society. Now, what we tried to do was to use our knowledge and expertise to push for this accountability, to make these moves, and therefore hopefully help others, or open the door for others, and make use of momentum, of attention that this topic is getting, but also of information that is coming out through these trials, so that others can use that and make something out of it, be it outside of the law, as I said, with all these other disciplines, but also to enable them to do this work themselves, so that we kind of pioneer this, but by doing so, others can kind of use this or their own approach to do something similar. And I'm quite happy that in the past year and a half, there's really an increase in Syrian organizations really taking ownership of this, not even asking us anymore, because they have seen now how this works and trying to push for this themselves, also legally, when, for example, filing a criminal complaint in France because of chemical weapons, or another really great example where family organizations of families of forcefully disappeared persons have created a coalition themselves in order to demand, for example, to learn more about the fate of their loved ones, etc., without any kind of or with little outside support and a lot of ownership. So this is I think at least I partly interpreted positively also as a result of this work, that this can empower others to see something is happening, and if a step is taken here, then maybe others can use that and go one step further, and so on and so forth. And we have seen that in many constellations where there is an impunity gap that it's really important. It's like basically, if you picture impunity like a wall, we try to make a little crack in it, and then maybe from this little crack you can there's a little piece falling out, and you can start taking apart and making a bigger hole in it after a while. Once the crack is in there, it's easier to continue basically deconstructing this wall of impunity. So that's the kind of overall vision, also by the ECCHR. That's in brief what we understand also with legal intervention. It goes beyond litigation. And now, lastly, before I'm done, I want to speak to you about another very concrete result of our work, and that is the Al-Khatib trial, which was actually pronounced very well. I found, not being a rabbit, of course, but having heard it many times. And this is kind of a result of all of this, basically, of the prosecutor's work, of our work, etc. And this is now for the first time that we have an actual trial that is taking place right now in the German city of Koblenz. You see a sketch of the accused on the far right. Next to him, his translator, and then next to that, to his left, the two persons are his two defense lawyers. The way this happened basically was that the accused Anwar R. arrived in Germany in 2017, and then it became known to the prosecutors that he was here. And because they had already a lot of this contextual knowledge from the structural investigation that we spoke about a minute ago, they could really, start with their investigations at a pretty advanced stage already. And it's been roughly at the same time when we were also engaged in this kind of work. And he was actually known to have directed, controlled, headed one of the most notorious and one of the biggest torture prisons in Damascus. He had defected in 2012 and come to Germany as a refugee, when the prosecutor started investigating, basically we helped them build the case and support witnesses and survivors in that case. Because they were so far advanced already with the structural investigation, they could already a year later arrest him and so to say accomplice who is of much lesser rank and importance here. That's why I focus on Anwar R. So in 2019, in February, he was arrested, and in October, it was indicted to the higher regional court of Koblenz that is now hearing the case. And he's indicted for at least 4,000 cases of torture and 58 killings as a crime against humanity in 2011 and 2012. And now if you consider this, that the prosecutors needed to be sure that it's at least 4,000 cases of torture, and this is only in the time frame from 2011 to 2012, and not even the end of 2012. And if you consider that such prisons that he directed, there are dozens, really several dozens of them all throughout the country, and they still function in the very same way up until this point, you kind of get an estimate also of the extent of torture that is happening in Syria. If one person for 1.5 years in one prison can already be indicted under criminal law standards for at least 4,000 cases of torture and 58 killings. And this has really, I think, been a very important aspect for the accountability movement for Syria, also for the Syrian civil society, when in April 2020, in April last year, in the height of the first wave of COVID, you see also one of the defenders wearing a mask. And this then resulted in the first trial opening ever for crimes against humanity against a former Syrian government member, and is ongoing since then. And I think this is really been a landmark and quite, despite all the difficulties, we have some advance here that relatively early on, so to say, we have a trial ongoing. And this is clearly, I think, a positive development. It's obviously a very first step only, but at least we could take that first step, which, given where the situation was in 2016, was not clear at all that this would happen. And as I said, the ECCHR, we are supporting 25 witnesses in this case. 14 of those are civil parties or plaintiffs in that case. With the civil law jurisdiction that we have in Germany, this is possible that victims actually very actively participate in this trial. As was said in the introduction, I personally represent, together with a partner lawyer, 10 victims of torture in this trial. And so far we have moved very swiftly, and we expect a verdict already in October 2021. That's all that I have from my side. I will stop the screen sharing, and I see that there were messages popping up in the chat and everything, but I'm sure that somebody will. So thank you very much, first of all, and I'm very happy to discuss and answer, of course, any questions you have.
Thank you so much, Patrick. This was really interesting to learn about, especially because I believe personally I haven't been exposed to the concept of universal jurisdiction, that too in this depth before. I would start with a question that I have, and then we'll move on to the questions that are there in the chat. So from what I've understood, and correct me if I'm wrong, is that the concept of universal jurisdiction has sort of come about due to the international failure to prevent the commission of such crimes, or because they weren't dealt with at a regional level or at a state level. So, which is why these particular states were given this universal jurisdiction to then deal with these matters. So what I wanted to ask you was, what would you say, how would you critically analyze the concept of universal jurisdiction, considering that only selective states have it? And would you say that there are chances of any bias involved with it, or so how would you critically analyze this concept is something that I'm trying.
Yeah, thanks. That's a really good question, and also a really good remark that I will address first, because you said, I mean, your understanding is correct that most state representatives would say that we need universal jurisdiction only when there's a failure of the other mechanisms. So they basically say that there's a hierarchy, that you have the home state having original jurisdiction, then the international tribunals or the ICC, and then universal jurisdiction. I would argue there are three pillars, and they are basically on the same level. And one doesn't prevent the other. Of course, when they both are competing with each other, the original jurisdiction is always going to prevail. The moment that Syria would say, I want to prosecute Anwar R., Germany would be barred also by Germany's very own law from prosecuting him, right? So I wouldn't say that there is a hierarchy. I would say that they are standing next to each other, but many state representatives say, no, we only need this kind of as a fallout option. But this is more of an academic debate. Concerning your question, I think you are right in pointing out to the danger, because of course there is this selectivity, and I'm saying, you know, of course doesn't mean that that I agree with that, but I say of course because it's one of the pillars, so to say, of our work as well, to address just that. In international criminal law, on all levels, like in international law, on all levels, you have a bias, and you have also a discriminating effect, or at least you have the problem that the most powerful actors in many instances are going to be able to avoid prosecution of any kind. And we have seen that with the ICC, where only weaker states are addressed, and we see that as well with the concept of universal jurisdiction. You know, so of course, you know, the post-colonial influence that is a determining factor in all international law is very present as well in universal jurisdiction. I think really that there's no way to argue against that. Our consequence from that is, however, that we still think it should be applied in these cases that are so clear. We say the response to that cannot be that we move away from Syria. The response has to be, let's look at Russia, let's look at the United States, let's look at Germany and the crimes that they committed. And also, you know, I mean, ideally also, I mean, obviously not applying modern international criminal law, but other forms of accountability, including colonial crimes, because this is where this whole concept comes from. So to have an equal application of these laws, you know, should not mean that we turn a blind eye to some, but that we look what others are doing. And so if you look at the overall work of the ECCHR, it's really, I would say, almost an exception that we contribute also in two cases where you know, weaker states, so to say, are being targeted by way of international criminal law, because we believe, as opposed to other organizations that say we cannot go along with that at all. But I mean, here we have a very clear situation of crimes on a massive scale that have been committed, and we have the possibility to prosecute them, etc. And for us, it can only work this way, you know, and we hope also that prosecutors, who sometimes, and I'm sure in India it's quite the same, think in very technical ways, that once that they have, you know, prosecuted and successfully prosecuted an international crimes case when it comes to Syria, they will have much more difficulties in saying, oh, well, but when it comes to the US torture system in Afghanistan, this is not the same. And it will kind of expose the fact that these are political arguments being brought forward. But this is the way that we try to play this, and we try to work against it. But in general, your comment, or where your question pointed to, namely that we do have this problem of selectivity, it's one of the main problems that we still live in, and we still have an international criminal law, and even more, it's a problem because it makes it possible for some countries to hide behind it. You know, if African head of states, or if powerful countries such as China say, this is an oppression tool of the West, they, of course, they only use that argument because they don't want to be prosecuted. But by being actually selective, these institutions present them this argument on a silver plate. The moment that they would go also after, for example, you know, US soldiers committing war crimes, or British soldiers or whatnot, then this argument would dissolve, and it would be clear what this is, namely just hiding behind this. But so far, this tendency is still very much present.
Thank you for answering my question. We have a question from Alicia. I think she would like to pose the question herself. Alicia, if you're there, you can go ahead.
Yeah, thank you very much. This was a very interesting talk. I think I have a question that is also related to selectivity, but sort of from a different perspective. So as far as I understand, universal jurisdiction could be used by any country, but only very countries use it in practice, actually. So I was wondering, what would motivate a country to do that, apart from the championing human rights, of course, but from a sort of cost benefit analysis, why would you investigate international crimes? And then also related to this, why is Germany at the forefront of this at the moment?
Thanks. Yeah. Also for making me remember something that I wanted to also say in the response to your question, Andrilla. So we mainly have countries from the global north, especially in Europe, that are exercising universal jurisdiction right now. And this is, the problem of selectivity very much present there, obviously, that we just spoke about. However, there are some exceptions, and these I find really interesting, and these I would hope to see develop more. Really, they can be kind of, singled out, for example, in Senegal, in South Africa, and in Argentina. You have rather wide and robust possibilities to bring such cases. Your question, Alicia, I don't feel in the position, I don't feel able to answer it actually, what the benefits, etc. are. I can say something, about Germany, but maybe going to these countries that I just spoke about. So Senegal used universal jurisdiction to hold a trial that was supported by the African Union against the former dictator of Chad, who was present in their territory. And it could also, lead to them looking at other crimes. And I would find it a great, development in international criminal law if, for example, they would say, let's look at Western companies contributing to international crimes on the African continent. We are assuming universal jurisdiction for that. And then, the question, is it actually three pillars that are standing equally next to each other, or is there a hierarchy, would become relevant. In the case of Argentina, it's also very interesting because this goes back basically to when the whole accountability movement for the Argentinian dictatorship crimes, I mean, this is, 40 years ago and more, started. And it's one of the examples where universal jurisdiction has been really successfully, I would argue, used to really trigger and then enforce an accountability movement that ultimately even affected the originating country. So right after the dictatorship, everybody in Argentina was really about amnesties and forgetting the crimes and moving on and so on and so forth. And the accountability movement really started outside. There were cases brought in Spain and Germany, etc., that led to some small results that could then be used by an extremely active Argentinian civil society, the Madre de Plazas de Mayo, for example, this big women's movement demanding to get information on their loved ones who were disappeared, etc. And so basically there started a back and forth that whatever was happening in the investigations here was being used in Argentina, which then maybe led to some more information being found somehow, which could then be translated back and so on and so forth. And this, led to some successful investigations in the course of decades, really, that we speak about. And at a certain point, what happened was that the Argentinian judiciary was given the opportunity to investigate these cases. And there is a very, very, huge wave of these investigations and trials currently happening now, examining their own dictatorship crimes. And it's certainly wouldn't have been possible without this very, very fierce involvement of Argentinian activists on the ground. But I would argue that they were in some ways supported also by this, this movement, so to say, outside of Argentina. And now what's happening, because Argentina does have a modern international criminal law, including universal jurisdiction, they are now looking at crimes that happened in Spain in the Franco era, and that in Spain nobody wants to hear about. So here really we see that this can also go back the other way. And this is exactly where I would see the future of progressive international criminal law happening, that it's becoming a more, a wider, applied system. But then again, what motivates them is really difficult to tell. In the case of Germany, Germany always tries to give the image of being, a human rights champion, especially with the violent, fascist history that it has. And that was one of the reasons why they always want to kind of be, the best pupil in class, so to say. And that's why they wanted to have a very wide-reaching code of international crimes right when the Rome Statute entered into force. And now they kind of feel that they need to do that. But when it comes to Germany, what is very important to note, and here we are speaking about selectivity again, they have a much easier time looking into the crimes of the Syrian government than into their own crimes. And the complicity of their government, and especially their companies, to international crimes happening. So we still have, as I said, this selectivity, or what I would call double standards in the application of international law and international criminal law.
Sorry, we have another question from Anshdeep. She asks, what is the locus requirement for invoking universal jurisdiction? Does it need to be a victim or a survivor or a next of kin, or any concerned person or NGO can approach?
So that very much depends on how that principle is basically enshrined in the specific jurisdiction. In Germany, the principle, as I said as I showed in the first slide, is very wide. Anybody can. This is the locus requirement. So first of all, the jurisdictional requirement is anybody can, but already that then is being limited on the prosecutorial level, that there has to be some relation to Germany. When it comes to who can file such a complaint, there is basically no limitation under German law. Anybody can file a complaint, but if there would be no relation to Germany, the prosecutors are very, very likely to dismiss it or not even take a decision on it, basically put it on a pile of all these complaints that you can probably imagine they receive these days, and would not follow up on that. But if, for example, there would be this relation, then anybody could file such a complaint, but only if you are affected by the crime in a direct way, meaning that you are a direct relative or that you yourself have been affected. You enjoy a specific set of rights when it comes to the investigation and to the non-opening of an investigation. Then they have to take a decision and notify you of that decision. If you are anybody, they can just be silent. If you are the kin or next of kin, then they have to notify you of any steps they take or don't take.
Thank you, Patrick. I have a follow-up question also to something that you had just said, that, because the prosecutor, the public prosecutor enjoys a wide discretion. So, we are a common law country, so I'm not really familiar with how the civil law, how administrative law shapes up in civil law jurisdictions. Because here, because our administrative law is fluid and ever evolving, so that allows us to ask for a lot of things to be subject to judicial review. So is that a possibility for all of you going forward to get the wide discretion that because like you said that Germany might be looking into crimes of Syria, but it's not looking into its own crimes, so, and that is due to this discretion. So is there going forward some way that administrative law could help you look at that?
Yeah, you are pointing to a very one of our wound points, so to say, because we are really mad about the lack of possibilities that we have to have some kind of judicial review of the prosecutorial discretion. So the possibilities that we have, especially with this, with this very wide wording that we have in the code that I shared with you, and that I can even try to share again.
Yes, it said me.
Sorry. Yeah, because this is so wide. If you want to, already in the investigation phase in Germany, the prosecutorial discretion is very wide. And here we even have the wide wording in case there's no connection to Germany, of course. And to get that reviewed is almost impossible. Yeah. And even if a decision to close, the kind of remedy that you have is procedurally extremely difficult to meet the standards, because basically you need yourself to hand over a case to the reviewing court that enables that court to take a decision to indict almost themselves, which, you know, as a civil person or organization, you're never able to do this. You're never able to, and you don't have any access to the case file at that point, right? So you basically need to do your own investigations, which you're not supposed to under, you know, in our legal system, etc. And it's extremely rare that the review court says, oh, well, this is compelling evidence, and I order you to go ahead with the investigation. So these are very, very weak points, and we are very frustrated with that and have been for many years.
There's another question from Wasim. He asks, how effective can universal jurisdiction be in case of the Israel-Palestine conflict?
Yeah, that's also a good and difficult question. I would say, how effective can any prosecution be in this conflict? Because the power games that apply here are very clear. I mean, I give you maybe to make my answer a bit more concrete to this very, very good but very wide question. We have tried to bring a case against the Israeli Defense Forces for the targeted killing of, for the killing of a German national. The family had been to Germany and they were visiting Gaza City in Palestine. And so, you know, since it's a German citizen, we know, okay, the wide discretion clause doesn't apply because we do have a connection to Germany. However, you know, if the country where the crime happened and that has direct, you know, active personality jurisdiction over the suspects, then also basically Germany is barred from investigating. And so in the beginning, you know, when we filed the case to the prosecutors here, they said, yeah, I mean, there was been, you know, it's basically been like a tower where there were some offices and there were also some apartments in Gaza City, and it was bombed with a huge bomb by an Israeli fighter plane. And there was allegedly some Hamas fighters also present in that building, but it was quite obvious that the family that had been killed, and one of them being a German national at the time, had nothing to do with that, and they were like 2 or 3 floors below or so. And the prosecutors first they were taking this on, but they didn't move it forward. I mean, with the fastest. I mean, it would be obviously, you know, a very delicate thing, you know, if Germany would indict Israeli soldiers for war crimes in Germany. So, but at least, I mean, something was happening, and Israel didn't. The Israeli Defense Forces and the Israeli government, they didn't comply with any request for mutual legal assistance. They really tried to delay this. And so the prosecutor said, well, what am I going to do? I need information from Israel. I'm not getting it. And so there was a deadlock some point in time. But when they started taking it seriously, the Israeli defensive forces said, well, you know what, we're investigating this ourselves. And this is one of the other techniques that many countries have in order to shield their own persons from prosecution. We also see it in the constellation where the British soldiers that have committed torture and other international crimes in Iraq, you remember maybe images from Abu Ghraib that went around the world, etc., these incidents, and we filed a case to the International Criminal Court for that. They also, because the International Criminal Court also has a clause, a complementarity clause, that whenever the state that has original jurisdiction is investigating, then the ICC is barred from jurisdiction. And it was really, I mean, in the case of the UK, it can be really called, sham investigations. And basically this led to the ICC still saying, oh, well, but they're investigating, so we can't do anything. And in the Israel situation, this has happened also to some degree, or at least the attempt of that happening. So countries like Israel, if no other consequence is happening, at least, they do have, a system installed where at least they can show to the outside we're investigating that. And since they will always, continue to make use of that, I see the prospect quite difficult. And then also, since you asked, and this basically means for all of international criminal law that comes from the outside to investigate, but since you asked specifically for universal jurisdiction as well, I see much more chances that the International Criminal Court is taking that on, because they have taken the decision that actually Palestine, should be deemed part of the ICC and should be able also to, or which basically would trigger jurisdiction for all the crimes that have happened on their territory. So, and that would be another way why countries exercising UJ would say, well, if there is the ICC doing these investigations, then we will refrain from it. So the answer is, unfortunately, likely not a very effective role.
Thank you, Patrick. I believe we have one last question from Aratrika Bhomik. Aratrika, if you would like to pose your question.
Hi, yes. Hi, Patrick. This was a very informative session. So I basically have two questions. First is, if we look at what's been happening in India, where we recently witnessed the Supreme Court allowing for the deportation of Rohingya refugees to Myanmar. And, we've seen states like India, which are not signatories to the Refugee Convention, and which has refused to accept non-refoulement as a principle of customary international law or a constitutional guarantee. So I just want to know what your opinion is in regards to the legal avenues available to such states, especially considering the principle of universal jurisdiction, because, like you were discussing, there's a hierarchy that has to be followed, which includes exhaustion of domestic remedies. And the second question that I had was in regards to, since we were discussing ICC cases, there has been recent criticism in regards to the ICC becoming redundant because of, the procedure outlined in the Rome Statute. So we've seen a lot of cases where, the public prosecutor goes into a state to, investigate an investigative stage in order to outline a prima facie case. But, we have willful interference of the state machinery into the investigative process, due to which, it's not a fruitful act. So what would be your opinion in regards to, kind of making sure that the investigative stage is not hampered so as to make sure ICC has jurisdiction in regards to crimes of humanity and war crimes? Thank you.
Thank you. So Myanmar is a really complicated situation, but it's also in a way emblematic to how the system of international justice works, and how civil society organizations, activists, from all over the place, really, in coalitions, try to overcome specific deadlocks that there are. And in the case of Myanmar, a lot has been tried already. There has been, for example, and this could be, become an important precedent where, the crime of deportation, basically, from Myanmar to Bangladesh has been used to argue that, because Myanmar is not a state party, but Bangladesh is, that part of that crime has taken place on the soil of Bangladesh, and therefore therefore the jurisdiction of the International Criminal Court is triggered. But so far, also here, we don't see any progress. And also when it comes, for example, to deportation from India to Myanmar, I mean, if first of all we think about substantive international criminal law, then we would need to see, could this, in the end, if it becomes if it is clear that the Rohingya people in Myanmar would be subject to an international crime, like a crime against humanity by whatever, be it enslavement or persecution or unlawful detention or whatnot, then this act could actually be complicit in that crime. It could actually be, you know, be marked as complicity, which would mean that under substantive international criminal law, the persons responsible for that, the individuals responsible for that in India could be subject to liability under international criminal law. Could, right? I mean, I'm saying this would need to be you know, thoroughly you know, analyzed, and I don't know the facts of the case at all to really have an opinion on that. I'm just outlining possibility here. But then in the next step, we would need to have jurisdiction somewhere. And as I said, attempts have been made for the ICC when it comes to the cross-border element between Bangladesh and Myanmar. In this case, it would be more complicated if there is no jurisdiction. Theoretically, if it is an international crime, as I said, any country in the world could take this on, but in practice, no country probably would without there being a specific tie to that country. So let's, I don't know, but if we use the example that maybe an Argentinian national or a German national has been part of the group that is forcefully deported, of course, the likelihood is very, very low. But sometimes you have people that were refugees elsewhere and they have, you know, nationality elsewhere. Then this, for example, could mean that at least concerning this case of this one person, another country would say, okay, we are going to investigate it. But this is all, you know, all of it a very long shot because it is actually, you know, the situation of the Rohingya people, one of the big also loopholes, so to say, so far, but also where many people are trying to overcome that, and there's quite a lot of action, so to say, on that side. Yeah, with the willful interference in investigations, we're also pointing to a very weak point of the ICC. The ICC has no own police or investigation force, so to say. I mean, of course, they have analysts, they have investigators, but they are always going to be depending on the cooperation of the state. And this will always, you know, be a very, you know, big possibility for that state to hamper the investigations and to influence them. But you know, with the system, you know, of sovereignty, the way that it is, I also really don't see it how it can be overcome. One of the things by which it is often overcome is that prosecutors look at evidence that is outside of these countries, and especially when you have you know, many people fleeing from crimes being committed, then there is the possibility. But the very weak point is that they always need to cooperate with you know, the authorities of a country that maybe they are investigating, and this is of course very complicated.
Thank you so much, Patrick. I think we'll end our discussion here. It's already 8:50. We've taken up a lot of your time. Are there any questions that anyone wants to pose? I will open the floor for discussion for another, say, 5 to 10 minutes. If not, then Patrick, what we can do is we can email you any further questions that we have or any follow-up questions, if that's okay with you.
Yes, that'd be great. I need to leave at the very latest in 10 minutes. So
all
yeah,
right.
But any other follow-up that you have, just yeah, happy to receive an email, as I said, and also I'm happy to share some reading material if some people would like to.
Yes, I will. You can email it to Sneha or I, and we can circulate it throughout. That won't be an issue. And any follow-up questions, we'll definitely email it to you. Thank you so much, Patrick, for joining us, and thank you so much for so patiently answering all our questions. Thank you to everyone for joining the lecture. I hope it was very interesting to know about. And we would look forward to seeing you in the next CCRI lecture. Patrick, I would hope that you also join us in our future CCRI lectures as well. Thank you, everyone. I'll end the meeting here. Thank you, Patrick.
Thank you very much also to you, Andrea, for the moderation.
No problem.
Bye-bye.
Bye.